All right, so this is our we're taking notes on the Supreme Court and the judicial branch of the United States. So you'll need to write this stuff down. In particular, I want you to pay attention to the words like this, like judicial review here, that are in this bright red font. Those are vocabulary words. We'll probably quiz on this information. They're important to know. So yeah, I'll just jump right in. So we're talking about the Supreme Court and in general the judicial branch of the United States. So to kind of go over some things that I think you already know about because we've talked about them. The Constitution is our highest law. That's underlined in the Supremacy Clause in Article 6 of the Constitution. It's the supreme law of the land. When there's a conflict with another law, the Constitution wins. So if Congress makes a law that disagrees with the Constitution is going to win. That law cannot be valid. The Supreme Court, and really the judicial branch in general, is responsible for upholding the Constitution. They have a power called judicial review that lets them look at a law and determine whether or not it is constitutional. They determine that the law is unconstitutional, that law cannot stand, and nor can other laws like it unless they, change to be constitutional. They have this because of a case that we're going to look more at in the future called Marbury versus Mass in the 1800s. It established the precedent of judicial review. So according to this principle, like I said, they can look at laws and determine whether or not they're constitutional. So in some ways, this kind of gives the court the ability to, almost like make laws. Because if they're saying one law can't be correct, it kind of means that the opposite is true. And I'll use this example twice, but there used to be laws that made different schools for different children. If you were, black, you went to one school. If you were white, you went to another. Essentially, the Supreme Court shot this down and made it to where we had to integrate. Kids had to all go to the same school. So effectively, they changed the rules when they did that. So that's a pretty big power that the Supreme Court has. However, there are also checks against this power. So it has a big check against Congress. If Congress makes a law that disagrees with the Constitution, the Supreme Court can shoot it down. Same with the president. If he makes an executive order that disagrees with the Constitution, the Supreme Court can shut it down. So along with that, the other branches of government also have checks against the judicial branch. If we want something to happen, and I'll use another kind of familiar example here. So, initially, when this country was founded, slavery existed. It was legal under the Constitution. The Supreme Court upheld it. However, in the 1860s, we have the Civil War. We decide that we don't want slavery to be legal anymore. Well, in that case, we're going to have to make a constitutional amendment because the Supreme Court had already established that slavery was in fact legal. So in that case, Congress gets together, they propose an amendment, and it gets voted through. Now the Constitution has changed, and now the court, when it's making decisions, has to look, it has to also include amendments to the Constitution, and that's how the court's power can kind of be overridden. It also has a check against it based on who chooses the justices. Presidents appoint Supreme Court justices as well as other federal judges. So these people don't run on their own, and they can't, the Supreme Court can't choose its own new members. The president gets to do that. So those are kind of part of those checks and balances that we'll keep talking about. All right, moving on. The Supreme Court, like I said, is the highest court in the U.S. And there's a system of courts in the federal branch that are all under the judicial branch that are there to settle questions about the laws. The Supreme Court is just the highest of those courts. There are 9 justices that can serve for as long as they live or until they retire, and each justice is chosen by the president and confirmed by the Senate. So both branches, Congress, or legislative and executive, get a say in who the Supreme Court justice is. And they check each other too. So like if the president, and this happens sometimes when the president is in one party and the Senate majority is in the other, the president might choose someone to be a Supreme Court justice, and if enough senators disagree with him, they might, vote that appointment down. Doesn't happen often, but it can happen. So that's how that's how these people get chosen. Some of the same information is going to be on this next slide. So just bear with me on that. So there are 9 justices on the Supreme Court in total. One of them is the Chief Justice. He's like the head. And there are 8 associate justices. John Roberts is our current Chief Justice. You don't have to like do anything special to be the Chief Justice. You get picked just like the rest to do that. John Roberts actually wasn't a Supreme Court justice before he was the Chief Supreme Court Justice. So you can just be, appointed into that role, or you can, already be on the court and then get moved to that position as well. Again, they serve for life. They are appointed by the president and then approved by the Senate. And the question here is, why not elect them? What's the purpose of appointment and approval? Like, why would we not hold elections? Because, I mean, these people have really important jobs. They're deciding what laws are constitutional and what aren't. It really has a real impact, as we'll see, on how life is lived in our country. And the answer to that is that is that we want these people to be impartial. We don't want them serving, political purposes while they're there. We want them to interpret the law. And the fear would be that, if they're running for reelection, they might make decisions based on what would get them reelected instead of what, the law says. So we want these people to be impartial. We don't want them to have outside pressure on their decision making. It's kind of a big idea there. This is where we'll stop for today. This last slide here. So I'll just kind of get through that really quickly. Like we said, the Supreme Court is the highest court in the nation. All decisions made there are final. You cannot appeal above the Supreme Court. And most cases that are in the Supreme Court do not start there. It's usually based on appellate jurisdiction, which means that it starts in a lower court and then gets appealed up to the Supreme Court. There are some cases that start in the Supreme Court where the Supreme Court has original jurisdiction, like these examples here, cases involving diplomats from other countries or disputes between the states, but they're not typical. It's not usually how it happens. Normally, a case starts in the lower court and gets appealed, like the lower court makes a decision. The party that, the ruling got made against appeals it to a higher court, and so on and so forth until it gets to the Supreme Court. Now, that does not mean that every case can get appealed to the Supreme Court. In theory, it could, but the Supreme Court is going to be pretty picky. Like you can see here, it only chooses about 150 of the thousands of appeals that they get every year. And they do that, they're trying to hear cases that are going to be important regarding the law. So you might see like a real blockbuster case every now and then that, is in the news a lot and it's a big deal, like a famous, murder case or something like that. But that doesn't mean it's going to go to the Supreme Court. The Supreme Court is choosing cases that are really going to have an impact on the law. So like one example I gave with my classes in Zoom today was, we're going to look at a case that was really all about whether students could wear an armband to school or not. And that might seem really trivial, but that course actually has a lot to say about freedom of expression and free speech, which is why they chose it. So they're choosing it more based on what the implications are going to be for the law than they are, how much of a blockbuster case it's going to be. So I'm stopping there. Just make sure you've got this down in your notes. Otherwise, let me know if you have any questions, and have a good day.